And so I'm going to start with the paper that I've done with Roza, and I'm just going to kick it off with a general analysis, and then she will unpack the details. So what have we been looking at in this research, which is called Corporate Purpose Beyond Borders, a Key to Saving the Planet, or Colonialism Repackaged? This starts from the idea of the corporate purpose debate. And it starts from the idea that in Anglo-America, if you look at corporate purpose and you go back 5 years, it was very simple. Corporate purpose was about maximizing shareholder value. But then in Anglo-America, you had this change, right? You had Larry Fink write a letter, you had the World Economic Forum, and you had this new epiphany that it's not just about maximizing shareholder value, that there's another purpose, okay? And that stakeholders should be taken into account. I'm not going to get into this room how this discussion completely ignores Asia. I have another paper called No Need for Asia to be Woke, which gets into that, okay? But that's been the debate. And how did that debate start? It actually started from this little New York Times article. And I'm always shocked that people don't just Google this, right? If you look at Milton Friedman's article, the social responsibility of business is to increase its profits, it's just a few pages. And this set the tone of the debate. There's people who love Friedman, and there's people who hate Friedman. But what Roza and I were interested in is that those who love Friedman and those who hate him, frame the issue in the same way. Those who love him say, keep stakeholders out of our corporate law. Those who hate him say, this has failed. Because if you just leave it to other regulation, you're going to have this horrible situation with climate change. This is not just Friedman. And I have Gengoto here, who's been heavily involved in the anatomy of corporate law. This is the leading book in the world on comparative corporate law. It's not just Friedman, though. Okay, the whole field has been looking at this on a jurisdiction by jurisdiction basis. But we all know that we live in a world today where problems aren't jurisdiction bound. There is no problem that's less jurisdictionally bound than climate change. And what does that mean? When you pollute a river and the water flows beyond a jurisdictional border, how does Friedman deal with this? The classic explanation is you don't put it in the corporate law, you put it in the domestic other laws. Why? Because you can vote to change those laws. Well, the person across the river has no vote. They can't do that. So how do you deal with it? That's the question that Roza and I look at. When you have these things that go beyond borders, and it's not that people haven't been dealing with it. People have been dealing with it. I showed you those newspaper articles. Europe has been dealing with it heavily at the state level. Firms like BlackRock, when they sit down, they don't make their sustainability rules for Singapore, for the United States, for Europe. They take one stand and they say this applies to the world. Transnational organizations, by their very nature, try to promote corporate rules that go beyond borders. And so what we're trying to talk about today, which is academic, but it really does have translational impact on the ground to practitioners, is that what is going on in Europe, that is affecting Asia. How do I know this? I've spoken as part of our research with a number of big law firms that have practice areas now devoted to this. With that, I will hand it over to my wonderful co-author, Roza, and I will let her unwrap the rest of the details of this. Thank you very much.
Thank you very much for everyone for joining us today. I will continue talking about our paper, which is Corporate Purpose Beyond Borders. And specifically because Dan already covered this idea of corporate purpose and the tension between global versus local, I will go straight to our taxonomy and 3 pillars that our taxonomy covers. So our taxonomy of global corporate law and governance talks about 3 major pillars. And these pillars are driven by 3 groups of actors: state, firms, and organizations. And it might seem that they exist in silence, but actually in our paper, we give examples of how these pillars interact, engage with each other, and overlap. So I will not talk about this, but let me go to the first pillar directly: state-based extraterritorial corporate law and governance. And in this pillar, we define as a state's initiatives that incentivize, or perhaps from other states' perspective, force states and their companies to adopt sustainable corporate governance, or they change corporate purpose beyond borders. And we use European Union example in our paper to illustrate the effect of state-based extraterritorial corporate governance. If you watch the news, you know the EU has been pretty active or even aggressive in this area by introducing legislation that has this extraterritorial effect. And they seek to fulfill two goals. First, they try to level the field for the European companies. And second, they try to drive sustainable corporate governance beyond borders. So they try to incentivize or force non-European companies to adopt EU design standards that might be beyond domestic standards. So we specifically refer to three pieces of legislation: Corporate Sustainability Reporting Directive, Corporate Sustainability Due Diligence Directive, and Carbon Tax. I will not talk about the reporting directive because I think other speakers will have a chance to unpack the idea about it. But what we find extremely important in the context of our paper is the enormous extraterritorial reach that each piece of legislation has. So if we talk about European corporate governance, Corporate Sustainability Reporting Directive, it clearly targets non-European companies. And the scope is quite unique because it applies a unique double materiality standard. For those of you who is familiar with the disclosure rules, usually they apply most jurisdictions, including ISSB, they apply a single materiality standard. So they focus on financial risks, climate and sustainability-related financial risks. Double materiality concept adopted by the EU applies a double materiality standard. So it includes two elements. First, financial perspective, a classic financial perspective. So information that would be relevant and material for investors and creditors. But the most importantly, it also applies impact perspective, information that would be material to employees, customers, vendors, and the community as a whole. So it targets the disclosure of issues that significantly impact the economy, environment, and the people. And that's very unique for the EU in this particular case. And because of the extraterritorial application, this double materiality standard crosses the European borders and goes beyond the EU borders. Then we talk about Corporate Sustainability Due Diligence Directive. Dan already mentioned there've been lots of drama going on recently around this directive because it's very controversial, but it clearly and directly targets non-European companies. In the previous draft and the draft that was approved by European Council a couple of weeks ago, two groups of non-European companies are targeted directly. Right, the sort of threshold, but it applies to non-European companies as well. And in terms of liability, it includes an important civil liability provision. Of course, before that, it also targets fiduciary duties of directors, but now they remove it. So the draft that was approved a couple of weeks ago looks much less ambitious because of the pressure, but still, it's a landmark piece of legislation that establishes obligations for companies to identify, assess, prevent, mitigate, address, and remedy actual and potential impacts on planet and the people. But most importantly, it's one of the first legislation that introduced a legally mandated standard for how companies conduct supply chain due diligence, and it could result in serious penalties if the companies fail to do so. Now, last but not least, we talk about carbon border adjustment mechanism. And you would ask me, well, we'll provide details about this mechanism in the paper. So for the sake of time, I will not do that now. But you would ask me why we talk about this fiscal policy in the context of corporate governance, right? But we think that it's important and has a indirect effect on how companies, on corporate governance of the companies. So even though it's not a classic corporate governance measure, it will incentivize non-European companies to implement cleaner industrial production and focus on climate, and as a result, adopt sustainable corporate governance practices. So we position this as indirect corporate governance measure. To sum up, both direct and indirect measures compel directors and executives of non-European companies to consider the interest of a broad range of issues, and rather than just focus on shareholder value maximization. So basically, that moves the corporate purpose beyond borders. Here, just to give you a snapshot of the recent OECD studies released again a few days ago, showing a clear extraterritorial effect of European Union legislation on other regions, right? So I think we don't need to, I don't need to emphasize this effect. It's enormous. Now, moving forward, the EU is not the only jurisdiction that imposes sustainability disclosure requirements that are likely to have extraterritorial effect. Other jurisdictions have been pretty active in this area. In our paper, we bring the example of California that adopted 3 major bills that aim to regulate sustainable corporate governance and companies' climate-related behavior. We also talk about Singapore, Hong Kong. We talk about China, but other speakers in the first half of the session will speak about other jurisdictions. But clearly, it's a global trend. Extraterritoriality is a global trend that we can observe. However, we also want to highlight that each pillar definitely generates certain benefits and has a positive effect, but it also has a dark side. So that's how we proceed and talk about. That's why we talk about colonialism or neo-colonialism or climate colonialism, because despite all the benefits that European Union tries to the benefits of the legislation that European Union tries to communicate to the world, many developing countries raise the issue of the fact that these regulations are discriminatory. Not only discriminatory, they would undermine the right of development by making their companies to focus, to shift their purpose from economic development within their borders to a new designed standard or a new design for purpose. So basically, colonialism repackaged. So I will not speak about dark side because I don't think I have time. But let's move to another pillar, firm-based, because we think that this pillar is equally important. The classic corporate purpose debate views the law and the state, which creates the law, as the major driver of corporate purpose. However, what we observe the emergence of the new pillar or the new actor, the firm. And given the wide range of discretion afforded to directors in corporate law, around the world, directors' focus can shift along the shareholder-stakeholder continuum, and as a result, significantly alter the corporate purpose they serve, even without changing the law. And that creates a powerful firm-based mechanism that drives corporate purpose beyond borders. And in our paper, we suggest that there are at least 2 ways for firms to do that. First, in large multinational firms, companies in the firm's supply chain will often be required to meet the sustainability standards set by the large commercial firm they are supplying, even if those standards go beyond what is required by the domestic law. We call it an IKEA impact. And number 2, in large investment firms, standards for sustainable investment will often require the investee companies to go beyond what the law requires to meet the terms of the investment agreement, or to shift their governance towards sustainability in response to the investor shareholder power. We call it a BlackRock effect. Well, you may question why, but that's another story, why we choose these particular names. However, this firm-based multi-jurisdictional corporate governance also has its dark side. And I will not go through these, arguments, but it's greenwashing, one size fits all, where we have a Western design corporate purpose applied across the board and across the jurisdictions, even though it might not actually fit. We don't think about other types of firm outside of multinational companies and investment and institutional investors. And it's also geopolitics, because large companies might fall victims of geopolitics or for the politics of the states that they affiliated with. So now let me move to the third pillar and final pillar, organization-based transnational corporate law and governance, because it's the product of a wide range of transnational organizations and their coordinated effort to advance corporate purpose beyond borders. And what we notice, and Dan already mentioned that, although this international transnational organization has been viewed as a source of institutional innovation in the past, we think that it's questionable whether in the future the same international organizations, which are increasingly viewed as a part of the Western world order, will be impactful as they are used to be in the past. And we discuss the rapid rise and increasing influence of BRICS Plus and China's Belt and Road Initiative. And we also observe a rise in the power and ambitions of regional organizations to create model of corporate governance that would fit and would tailor the needs of a particular region. In our case, Asia. And in this case, we refer to the Asian Development Bank and Stewardship Asia Initiative, and their effort illustrate another clear example of transnational organization-based corporate governance being driven beyond borders, but in the context of a specific region, Asia. So the question is that maybe in the future, in this newly, divided and regionalized world, transnational organization-based corporate governance may be more regionally focused and less influential than it used to be in the past. So let me, this is the summary, and let me move to kind of the final slide, because although we tried to cover, and we did cover many points in our paper, we still think that there are lots of questions remain. We talk about 3 pillars, but what are other pillars? We can see and observe the rise of climate-related litigation, and courts become quite involved in this area. So do we have other pillars that will drive corporate purpose beyond borders and will be a grounding points for global corporate law and governance? Also, the question is, what are the determinants in which state-based extraterritorial corporate law and governance have the greatest or least potential to drive corporate purpose beyond borders? We talk about at least 2 determinants, but they incorporate commercial leverage and regulatory capacity, but maybe there are others. And what jurisdictions do possess the most capacity to drive sustainable corporate governance, especially with respect to major polluting states? So that's just a few questions to finish my talk. Thank you very much for your attention. If you have any questions, please let me know. Thank you.